Good morning, afternoon, or evening. I am Stephanie Joy with All Things Social Security and the attorney at Joy Disability. You're about to see what should be a question and answer format type of chat from our live session on a particular topic that we find that a lot of people keep asking about. So I'm sharing it here. If there are pieces that could have been added that weren't added during the live, because there's a kind of a fast-paced Q&A that we do every Wednesday at 1 p.m. You might just find that I added something to the end of it to give it a little more clarity and a little more details for those that are interested in that particular topic. So check to see if that's at the end. Otherwise, enjoy the video. Bye-bye. If I provide medical docs, does SSA request them again for themselves? Okay, I don't know if you filed yet for your Social Security disability yet, but I would not send them up unless you had an entirely complete set from beginning or at least a few years before you're disabled to today or whatever. Like fully complete as of now. And I would only do it after you get an adjudicator. Do not give it to the field office. I find that it rarely makes it up into the file, and here you are thinking it's all sitting pretty up there and it's never there. I would wait till you get an adjudicator, and if you want to send it, and only do it if it's fully up to par at that time, because I think what happens sometimes is they see that the claimant sent the records, at least for that provider. And you want to, if you're going to send multiple providers, do not put them on one big stack. Delineate them out, identify which ones they are. And if there's going to be more visits, say this is up to here, but there will be more visits. Because I have seen adjudicators, and this is not to say all of them, I can't speak for all of them, I'm just saying from experience I've seen, sometimes they won't order them. Oh, I don't have to get Dr. Jones because she sent them. And a lot of times people are sending partials. And, it's not even the full medical record, it's just maybe some visit notes they had. Even if they had every visit notes, but they don't have everything else. And now you just gave them a reason to not have to do that. And I get it, they don't want to waste their own time. But that's because they think it's all there. But what if you're still going? Or what if you only had it through December 2025 when you last got them? And, and if you're thinking that portal records are the same as the official record set, that's not true. They're very helpful, but don't make sure you know that they're not the same generally as the official record set. For instance, portal records, when you print them out, do not show, at least for the major portal companies, all the messaging you did with your doctor. Tell them about this complaint before the next appointment, and can we go over this when I get there because this has been really bad. It's been really holding me back, or keep me in bed too many days a week than I would prefer. All those messages not there when you do the document dump from the portal. For the gold standard portals, even that have that opportunity to do a document dump from X date to X date, I want everything. Some of these more mom and pop, I'm not going to say their names, but if you're not, put it this way, many of them, if they're not Epic, My Chart, I think those go together, I'm not sure. They'll have it where you have to go in and print every test out separately, every visit note separately. I mean, you can't just go and get what would be the full McCoy for each date, or all date from this date to this date. And it is a pain in the rear. And then some of them, and I thought this was not legal anymore, but some of them don't provide their progress notes in all that little nitpicky stuff you have to do. And I find that really annoying. Oh, well, you can make an appointment here and you can do this and you can get your test results, but not the doctor's notes. Why? So just be careful when you do it, and then make sure that if you're going to do it, make sure that you let them know that I'm still going to Dr. Jones. This is just through this date. Please order them again from this date, going forward. And that's the risk you would run, Sarah. I mean, if they order them again, that's on them. I wouldn't worry about that too much. That's their problem if they have to read through 2 sets. But my concern is if they don't and you continue to see, or you sent in partial and think that they're going to go get the rest, that's not going to necessarily happen. Hey there. Welcome to All Things Social Security. I'm Stephanie Joy. Whether you are a first-time viewer, an occasional viewer, a subscriber, or one of the 3 tiered benefactor members, I want to welcome you and let your video begin. Remember, if you haven't checked out the memberships, it might be something up your alley because it gives you an opportunity for a little more Social Security disability attorney attention if you need it, but don't have representation and don't want to do a full-fledged consultation. Okay. Have a great one, guys. Stay tuned. Hey, all. Okay. I just wanted to give a little share here for those of you that are pro se and with representation, if your representative filed as a third party, your application online. We've gone over this before, I think, but I want to hone in on something in particular. You're going to get, by and large, a copy of the printout of the SSA's printout version of what was ever filed electronically in terms of the application. And it's going to ask you to, see if it's correct, blah, 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 make any corrections, initial them, and sign the signature page. There's also potentially going to be some additional documents in there that you would generally want to sign. That might be the 827. These might be in there even if, like in our case, we send these documents with our representation documents the second we file your online application. We get those in, but the left hand doesn't know what the right hand's doing. Oh, I did that right. And they will re-ask it again. Their letters are canned. When I say canned, I don't know if my generation probably knows what that means. They're just repeated, cover everybody type of letters. So they often say things that don't apply to you. In this case, they're going to ask for all the things that they may already have, or they may have lost them. I mean, we've had it where they don't know, someone did not scan or do what they were supposed to do with the incoming mail. So we have all those kind of issues. So if they ask for it, just sign it and give it to them again. If they ask for a W-2 from the most recent tax filing year, you're going to want to send that. And that's usually because they don't yet have the IRS information from your tax filing. Therefore, you're not, otherwise your benefits aren't reflecting, your benefit amount, should you prevail, is not reflecting that latest income that you've already done and that you're entitled to. It also probably helps them confirm and inquire as to whether you actually stopped working, when you did, if you said you stopped in 2023 or 2024 or 2022. So there could be a multitude of reasons for that. I'd go ahead and get them that. If they ask for a most recent pay stub, go ahead and get them that. If they ask for, and they do every single time, get us all the medical records you have going back, blah, blah. In my opinion, and sorry, I'm sure some people, do this regularly and they don't care. I don't recommend you do this. I don't do, I tell my clients, no, do not send your mishmash of partial records to the SSA. And here's why. First, it's not at the adjudicator stage. I have seen people send in medical records and they disappear. They never get in the file. They're never there when it gets into the gets to the DDS level and we can see what's in that file now. So it's a waste of time and your energy, and potentially if you weren't, bright enough to send them a copy and not send them the only copy you have, those records are now gone. For old records, that can be very detrimental because they're often no longer available from the provider. Another reason is, and I know this is not going to be taken well by maybe staffers or whatever, but I've seen it more often than not, at least back when people used to do this and we didn't, get on top of it. If the DDS gets the copy you sent to the field office of a mishmash of medical records from a variety, one or more doctors, I have seen them refrain from ordering the full medical record set from the provider that you sent one visit record on that you happen to have. So your case is plugging along and they're relying only on that one record and they're not ordering the rest. And their obligation is to order those records for you from every provider that you put in your application at a minimum. So I get the impression, and I have colleagues who have had the same experience and same impression, that it might be a DDS adjudicator here and there who have the mindset of, oh, they sent Dr. Jones records, 3 pages. I don't have to order that one. That's not accurate, but you know, we're not fighting City Hall here. We're fighting for your case. So what I suggest, and very important for my clients, and if they didn't follow this instruction, or it could be a deal breaker, don't send it. Send it to your lawyer. Send it to me if I'm your lawyer. You know, upload it to our portal. But don't just send it to, it's a ghost right now. You don't even have an adjudicator, you know? So even if you send it to the field office, they may or may not send it up the pike when they send your application up the pike, which can then be sitting there for nowadays, right now, it could be 6 to 8 months. They're so short staffed. I wouldn't do it. At times I will send later on, once we get an adjudicator, the segregated mishmash of medical records, miscellaneous records. But I emphasize in a cover letter that this is not the complete record set. And please, you know, complete your obligation of ordering all the doctor's records that we put in the application, separate and aside from the miscellaneous. Now, why send the miscellaneous at all? Questionable, right? The only reason I might do that at that juncture is because what if they see in the mishmash what we know about the claimant? What if that is enough for them to be like, ooh, listing, or ooh, you know, I think this guy's prevailing. You know, why delay that for my client? I can't say that that's ever happened though, but there's always the hope. And I don't, you know, if there's a 1% chance that my client can win sooner than he would otherwise win, maybe you'd have to go through the full initial that's even longer, or go to recon. If I can get it faster, I think that's my duty and my obligation. So I will do that, but it will always be with a very firm description that this is miscellaneous medical records and not the full record set from anybody. Only the few sporadic ones in the possession of. So anyway, that is what all minds can, I'm sure, reasonably differ, but that's how I do it. And I feel like it greatly contributes to better results, faster results, and higher winning rates as a result. Okay, so there you got it. I'll talk to you guys later. Bye.